Good afternoon, everyone, and thank you for attending EDGE's webinar. My name is Meredith, and I'll be your moderator this afternoon. Today's presentation is entitled, Getting the Most Out of Your Drug Testing Policy. It's scheduled to last about 45 minutes, and that includes a Q&A session at the conclusion. Our presenter today is Bill Current. Mr. Current founded WFC and Associates, LLC, a national consulting firm that specializes in drug testing policy development in 1998 and continues as the president of WFC today. Mr. Current is also the editor of the online Ultimate Guide to State Drug Testing Laws, located at statedrugtestinglaws.com. He is also the publisher of several e-newsletters, including State Drug Testing Laws Monthly and the weekly e-news service Drug Testing in the News. Mr. Current is the former executive director of the American Council for Drug Education and was the first director of the Institute for a Drug-Free Workplace. He also served as vice president of consulting for a national third-party administrator of drug testing and background screening service. Mr. Current is the author or co-author of 10 books on substance abuse issues, including one entitled Why Drug Testing. He also administers the annual Drug Testing Industry Survey, which is now in its 15th year. During today's webinar, we hope to educate you on the benefits of having a successful drug-free workplace program in place. Some of the items that will be covered in today's presentation are the 5 essential components of a comprehensive and compliant drug testing policy, how to accurately identify your drug testing objectives and create a policy that maximizes those objectives, and how to correctly comply with applicable state laws for drug testing. As a reminder, we'll be taking all questions at the end of the webinar. Therefore, if you'd like to send us your questions, just type them in the questions box in your GoToWebinar dashboard and press send. And without further ado, I'll let Bill Current get started.
Well, thank you very much. It's a pleasure to be with you today. And I want to thank EDGE for putting on these webinars and providing educational information for people in the industry and for people who use the services of the drug testing industry. I know from what you just heard, it sounds like we're going to cover a lot today, and we're going to try to pack it in a little bit, but as Meredith said, please submit your questions so that we can take the time to answer them, and if there are any questions that we can't get to because we've run out of time, then I'll get with Meredith and try to respond to those questions for you offline as well. So let's get going. What I'd like to do is start out with some statistics just to kind of set the stage for the discussion of why a drug testing policy is so important, and then that will launch us into the components of the policy and how to make that policy really work. Every year, the federal government puts out a study called the National Survey on Drug Use and Health. It used to be called the National Household Survey on Drug Abuse, and several years ago they changed it to this title. And this is a long-running national survey. It goes back into the 1970s and different iterations and whatnot, but it's really a great barometer to look at the levels and the prevalence of drug abuse in the United States in all kinds of different categories. And so you can go on to the website at the Substance Abuse and Mental Health Services Administration, the SAMHSA website. The address is at the bottom there, the URL. And you can look at this study, and you can see that it breaks it down into all kinds of different categories. So I'm just barely scratching the surface today, but I want to make a few points. And one is that between 2008 and 2011, keep in mind the 2011 statistics came out in 2012. It's always sort of a year behind. Illicit drug use in the United States increased. Among 12 and older, the level of drug abuse was up from 8% in 2008 to 8.7% last year in the study that came out last year. Well, 0.7% is fairly significant when you're talking about as many people as there are in the United States. And so 8.7% represents over 22 million people who self-identify as current illicit drug users. And to help you better understand this, and just in case you don't know, the government defines a current illicit drug user is someone who admits to using an illicit drug at least one time in the 30 days just prior to being part of the survey. So that doesn't mean they only used once, but they admit to using at least one time in the 30 days prior to the survey. If you go on to the website, you'll see that you can break it down by current illicit drug users, the last 30 days, but also past year users, those who admit to using an illicit drug at least one time in the last 12 months, and then those who admit to using illicit drugs at least once in their lifetime. And so as you broaden that definition to last year or lifetime, of course the percentage goes up significantly. But we can see that drug abuse generally has been going up over the last few years. And at the center of this increase is the current use of marijuana. That's the prime factor in the overall rise in illicit drug use. 18.1 million Americans admitted to being current users of marijuana in the survey that came out last year. That's up from 14.5 million in 2007. So a very significant increase. And according to the government's report, this is what they wrote, quote, the rate of current marijuana use among youth aged 12 to 17 decreased from 8.2% in 2002 to 6.7% in 2006, remained somewhat the same through 2008, and then started to increase again. And I like the wording here, right? Because, you know, the old saying, there's statistics, there's, I forget the old saying, but it'll come back to me in a second, but you can sort of make these numbers sound any way you want to. So again, we're talking about many, many millions of people among those 12 to 17 in the United States. It says that the rate increased to 7.4% in 2009, and then in 2010 and 2011, the rates were very similar. But you can see it went up from 7.4 to 7.9, so 0.5%. When you're talking about as many million people as we are, that's not really an insignificant or a statistically insignificant increase. That's pretty important. And one of the reasons why I go from, you know, pointing out that marijuana use is at the core of the increase, and then that drug abuse among young people is also going up, if it's not, you know, even if it's just slight by the government's estimation, is that many people, of course, are hiring teenagers and young adults. And so today's teen drug user is tomorrow's job applicant. So it's important to be aware that drug abuse is up. At the core of it is marijuana abuse, and of course marijuana is all over the headlines these days because Colorado and Washington actually passed laws, voters passed laws back in November legalizing the recreational use of marijuana. And I won't take the time to you know, sort of get on my soapbox on the use of the word recreational, but there's also an increase in drug use and marijuana use specifically among young people, and that portends further problems in the future, especially as states start legalizing marijuana. And I should point out, in fairness, that the Colorado and the Washington laws that legalize marijuana use are for 21 and older, so it wouldn't necessarily increase, we wouldn't necessarily see an increase in use among 12 to 17-year-olds, but we could probably see how it might, as those barriers come down, result in an increase among young people. But we're definitely going to see an increase among adults 21 and older. Now, how are these trends playing out in the workplace? This is very interesting. The first bullet deals with unemployed adults. And of course, we saw last week when the unemployment figures came out that unemployment is starting to creep back up again. We're almost back to 8%. 17.2% of unemployed adults 18 and older admitted to being current illicit drug users, according to the survey that came out last year. This is reflecting statistics from 2011. Among those who were employed, 8% of full-time workers and 11.6%, 11.5% of those employed part-time also admitted to being current illicit drug users. And so that's 19.6%, or 1 in 5 when you combine the full and the part-time workers together. 1 in 5 workers admit to being current illicit drug users. And when you take it and you look at the illicit drug users as a whole, the category of illicit drug users, most of them had jobs. Of the nearly 20 million current illicit drug users aged 18 or older, 65.7%, or 13.1 million, were actually employed, either full or part-time. So a lot of workers are using drugs. There's just no way around that. And an even greater percentage of people who are unemployed, some of whom, most of whom, are looking for a job, over 17% of them admit to being current illicit drug users. Now, before we leave this whole topic of the statistics, and particularly the ones that come from this SAMHSA survey, it's important to know that the government, years ago, issued a study, the results of a study that they did on their study, on this survey, because you can imagine how people might not be entirely honest when talking about their illegal drug use behavior when they're on the phone being surveyed by a representative of the federal government. Some people might not tell the truth. And in fact, in the study of the study, they found that the results were as much as 1/3 below what they really are, underestimating the level of drug abuse by possibly 1/3. So these numbers are frightening enough. But just imagine if they were 1/3 higher than what we have here. And that's a distinct possibility. So the numbers are the best that we have, but they may actually be underestimating the magnitude of the problem. Now, the impact on the workplace is all over the place, right? You have, reduced productivity, increased absenteeism that contributes to lower productivity, careless behavior, risky behavior, confrontations in the workplace, all kinds of problems that sort of get manifested into the workplace when employees have drug problems or substance abuse problems in their life. The statistics that we've looked at so far only deal with illicit drug use. You can go onto that SAMHSA website and you can also read the statistics that have to deal with alcohol abuse, which is a much bigger problem. And so the impact on the workplace just from illicit drug use are very, very significant. And these are just some generic terms that I've thrown out there. Now, I wrote a book several years ago called Why Drug Testing, and I put a lot of statistics into it. I tried to find the sources of all these numbers that we see being thrown around so that people could actually go back and read the actual studies. But some of the numbers that I came up with that I used in the book, some of them are old, but again, when you look at studies, prevalence of drug use changes from year to year, but the impact of drug use doesn't necessarily change. So some of these studies and these statistics on this page, being a little bit old, are nonetheless still important and significant today. So 38 to 50% of all workers' comp claims are actually related to workplace substance abuse issues, and that a substance abusing worker is actually 3 to 5 times more likely to file a workers' compensation claim compared to their non-substance abusing coworkers. Substance abusers incur 300% higher medical costs compared again to their non-substance abusing coworkers. 2.5 times more likely to be absent, 8 or more days a year, and 33% less productive. I like to think about it. I have employees too, just like you do, and so if I'm paying somebody $20 an hour, let's round it up to $21 so I can do the math. Well, I'm paying an extra $7 an hour for this person to be less productive if, in fact, they're a substance abuser. Now, it's not quite all that simple, but you get the point. Substance abusers tend to be less productive in a lot of ways, and it goes back to the list that we were just looking at on the previous 2 slides. They don't show up to work on time, or they are absent more often, or they're less productive. They come back from lunch breaks a little later, etc., and then it takes them time to get into their work pace again. 37% of substance abusing workers with small companies worked for 3 or more employers in the past year, and 53% worked for 2 or more employers in the past year. That's significant. I mean, now it's, the government defines a small company as fewer than 500 employees, but this is significant because you know what it takes in terms of dollars to go out and find somebody and hire that individual and then train them in the job that you need them to do. And to think that, over 1/3 of them are switching jobs a year or 2 or 3 times a year. You go to that last bullet there, 7% of current drug users with small companies were fired. 9% were laid off, and 29, almost 30%, voluntarily left. So this is significant. This is another area of substance abuse, sort of what I sometimes call the hidden costs of substance abuse in the workplace that are significant, that we need to be aware of, whether you're with a small company or a large company. Now, years ago, the Navy did a study. It was a very, very famous study at the time. Came out in the sort of the late 1990s and then got thrown around in different iterations during the 2000s. And according to the study, a typical substance abusing employee costs his or her employer about $7,000 a year in just two categories: lost productivity and replacement costs. And there have been a number of studies out there, they're all over the place, that sort of try to add up all the costs to the employer community. And it ranges from $600 billion a year to $200 billion a year. But I really think it's that $7,000 number that really matters the most if you're a small business owner like myself, because that's a lot of money. That's a lot of money to a small business, $7,000 a year. The $60 billion, the $200 billion, I maybe can't relate to that as a small business owner. Maybe you can't either. But the $7,000 a year is significant. And then you have to kind of look at it. Well, how many of my workers, if I have 100 employees, what percentage of my workforce are current illicit drug users? And then you multiply that by 7,000, and that kind of starts to give you a number. Of course, if one of those workers files a workers' comp claim and gets a $45,000 judgment in their favor, then, of course, that $7,000 figure just got blown out of the water. Okay, so there are circumstances in which these figures could be very low. Now, all of that sets the stage for a discussion about a comprehensive approach to a drug-free workplace, and particularly a drug-free workplace policy. So we've established the fact that drug abuse in the United States is going up. Marijuana is at the core of the increase. We've got to watch it among young people as well. Today's teen drug user is tomorrow's job applicant. And there are many different ways in which drug abuse negatively impacts the workplace in terms of all kinds of things, from safety to productivity and to the dollars that are associated with that. So it's really, really a smart move, a no-brainer, to use the terminology that we often hear, to have a drug-free workplace program in place. And that starts with 5 key components. And there are variations of each of these 5. But let me go through them. There's having a written policy, some type of supervisor management training program in place, an employee education program on the dangers of drug abuse, drug and alcohol testing, that's a big part of it. That dominates usually a drug-free workplace policy, and then some type of an employee assistance program or employee assistance services. And so we're going to go through these line by line as they pertain to a policy. And so within the policy, there are several components that are almost always in a good policy, to varying degrees of detail, okay? But I always start, and I write policies for a living, so I'm always writing policies for companies. And I always start with a purpose statement. Then I go into the authority, the coverage, who the policy covers, the training and the education components, whatever type of employee assistance the company is going to provide, which could be very minimal unless you or they are in a state that requires a formal EAP, what type of conduct is prohibited by the company, how drug and alcohol testing will be conducted and under what circumstances, the consequences for a policy violation, and then if you're a multi-state employer, what state law amendments are you going to add to the policy if you're in one state and you base your policy on that state, but you're in other states where you have to comply with those laws as well. You don't necessarily have to rewrite the entire policy or have multiple policies, but you will want an amendment to cover those additional states. So we're going to go through these. So first, the purpose statement. This is where you identify in writing what your objectives are. Now, most people just think of it as drug testing, okay? I call it a drug-free workplace policy, a drug-free workplace program. Lots of people just simply refer to it as their drug testing policy, and that's fine. Sometimes the terms are interchangeable. But if drug testing is the core of your policy, then what are your objectives? What is it that you're trying to accomplish by doing drug testing? What do you hope to accomplish? The purpose statement comes at the beginning because everything after that is a reflection of what you're trying to accomplish with your program. So your purpose statement is very important. It may seem like an exercise in, in just sort of wording, but the reality is a well-crafted purpose statement, even if you're borrowing generic terms and inserting them into your purpose statement, is really important because some of the things that follow are directly related to that, such as supervisor training and employee education, which I'll talk to in a minute. And then this is also a good place to insert, to some extent in detail, any state or federal regulations that have prompted or motivating not only the drug testing itself, but how the policy is going to be put together. So obviously, if you're a company that falls under the mandate of the U.S. Department of Transportation, maybe you're under the Federal Motor Carrier Safety Administration, then you know what you've got to have in your policy. It's right there in 49 CFR Part 40 to start with, and then beyond that. So your policy is going to contain what the government tells you to do. If you're here in Florida, where I'm at, probably many of you as well, and you're going to participate in the drug-free workplace program in the state that offers a 5% workers' comp premium discount to companies that qualify and then comply with and participate in the program, then there's certain things under that program that have to be in your policy. But your purpose statement can be, a declaration that we are going to comply with the following law or regulation, but it's much more than that. It's really articulating at the very beginning for all of your management and your employees to be able to see, this is why we're doing this. This is what's important to us. This is what we hope to accomplish by having this program in place. And then I always recommend that the purpose statement be followed by some type of an authority statement. Who can actually authorize a drug test? Who can answer questions for employees? If an employee has an issue, if an employee witnesses something or suspects something, with whom should they talk? Who is the director of your program? In a DOT policy, it's going to probably be your DER that's listed there. But who is that person? Or are there layers of individuals that authority has to come from? Working from a local to a regional to a national level. That can all be stated here so that the policy clearly states who's in charge, who has the authority to authorize a drug test, who can answer our questions, and here's how to get a hold of that person or that department. And then who is covered by this policy? Is it just a pre-employment drug testing screening program and only job applicants are covered by it? Or does it apply to employees as well? And then within each of those two categories, which people? Is it all job applicants? Is it all employees, part-time, full-time? What about seasonal or temporary workers or union workers? Are union workers under some type of an agreement that's different than the one that's reflected in the policy? That can all be stated here, even if you're referring the reader to another policy that applies to the union workers or to an appendix in the policy that applies specifically to the union workers. If you are a company with, one population of employees who are not covered by DOT, and then you've got, 16 drivers who are, you might use that space there also to refer the reader to your dedicated DOT drug testing policy. But this is an important part of any policy to state who is affected by the policy and under what circumstances. Now, I'm not going to spend a lot of time on training and education, but this is an important part of an overall drug-free workplace program. And the government, again, did a study some years ago in which they determined that companies that combine drug testing with supervisor training / employee education and some type of an employee assistance program or service of some sort will have a 33% greater chance of actually achieving their drug-free workplace objectives. Now, that may seem obvious on the surface, right? In other words, if this policy is dependent on how well your supervisor understand what's in the policy and what their role is in carrying out the policy, then you definitely want to have a supervisor training component somewhat identified and explained in the policy. And then, of course, it helps when your employees understand what's required of them as well. So these two areas, supervisor training and employee education, can be handled very generically. You know, an hour on the effects of drug abuse and an hour on the effects of alcohol abuse. But I like to focus the training not only on those things, which are important, but also what are the expectations of this policy for supervisors, and what are the expectations of this policy for employees? Who is responsible to do what? And when employees understand that the company does X, Y, and Z to maintain a drug-free workplace, including, among other things, drug testing, for example, it increases the chances that someone who is a quote-unquote casual drug user is not likely, or is less likely, let's put it that way, to show up to work under the influence of drugs, or to bring drugs to work with the idea that they're going to smoke a joint on their lunch break, if they understand what's required of them. And we're going to get into the consequences here in a second. Let me touch on employee assistance just briefly here as well, and then we'll get into the drug testing issues. An employee assistance program can be as formal as, you know, something that you hire a third party to provide to your employees that covers, among many other things, treatment related to substance abuse issues for employees and perhaps for members of their family. But it can be as informal as simply providing information, contact information, 800 numbers or other phone numbers of services that are available in your community or in the community where that business operation is located. So on the one hand, you've got a formal EAP, and on the other hand, you have the company pointing workers in the direction of where they can find help on their own. Who's going to pay for the services? What do the services include? That just depends on what you're providing or what you're not providing. There are states that have very specific laws that require a formal EAP in order to do drug testing. Not very many states anymore. Used to be much more common to see that. There are still a few states like that, but most states will leave a lot of that to the employer to decide. So you may have an EAP program that you're already offering or that your client is already offering, and that can be, you know, an explanation, a brief explanation of what those services include and what phone numbers or email addresses or website address the individual can use to access or find out more about those services. It can be just that simple. Now, prohibited conduct is a really important part of a policy. And there are really two schools of thought when it comes to the components of your policy and how much you put in it. I'm of the opinion that more is better. So in other words, I'll read policies that have been put together by who knows whom that cover prohibited conduct in one brief paragraph. And then you'll see a policy that I write or other people write that has a long list of different types of behaviors that are prohibited under the policy. I've just put a few here. Most policies I read don't have bullet number 1 in the policy, testing positive for drugs. But I put it right, or alcohol, but I suggest putting it right there at the beginning and making that, obviously, a violation of company policy, testing positive. Also, being under the influence while at work. This is a key point. Years and years ago, through various legal challenges to drug testing, you hardly ever see it anymore in any type of legal challenges. But years and years ago, this was a big issue. And we sort of ascertained from numerous court decisions that a drug test doesn't technically prove that someone's impaired, that they may be impaired. It may be obvious to you and me that they're impaired, but the drug test itself, under the scrutiny of the legal system, doesn't really prove impairment. So we have to sort of define it in our company policy. And so I recommend having a definition of what you as an employer considers under the influence. So under the influence could be testing positive, or it could be showing the outward signs or manifestations of someone who's been using drugs or alcohol. It could be smelling of alcohol or smelling of marijuana or any number of things. You can go on to lots of different websites and find lists of what those could be, and you could probably, think it through and come up with those on your own. But I like to include under the influence a positive drug test or alcohol test. That's a violation of the company policy. A .04 blood alcohol content level or greater, or, a positive drug test at the cutoff levels that are later included in this policy. Using drugs and alcohol while at work, that seems like a no-brainer. Selling drugs or giving drugs or sharing drugs while at work. Legal problems associated with drug abuse. A really good policy will require individuals to report to the employer within a few days, 5 days, let's say, or maybe immediately if they are convicted of some type of drug or alcohol violation. And then make sure that you include in the policy individuals who cheat on the drug test. That's a huge issue right now and has been for years in our industry. You can go on to the internet, you can do a Google search on cheating on a drug test or passing a drug test, for example, but you can also do a Google search just on drug testing. And a lot of these websites that offer advice and sell products to help people cheat when it comes to drug testing will pop up. And so that's a big issue, and there's lots of different ways to articulate drug test cheating, but I always recommend putting it in the policy. And then somebody who refuses to be tested or somehow goes through whatever, efforts to avoid being tested, that needs to be articulated in the policy as well. And there are other areas as well. These are the main ones. Now, when it comes to drug and alcohol testing, remember, at the beginning, we talked about your drug testing objectives. And so the whole drug and alcohol testing section of a policy is going to really start to reflect those objectives that were articulated in the purpose statement. So how testing will be conducted, any of the service providers that are involved in delivering the drug testing service or related services, and then, of course, when testing will occur, pre-employment, post-accident, reasonable suspicion or for cause, random, return to duty follow-up. Those are the main categories. And we can come back to this in a second and go into a little bit more detail about that. But the drug and alcohol testing section of the policy is where you get into how you're going to test, who's going to be subject to the test, of course, a reflection of what we had earlier in the policy, and then under what circumstances drug testing will occur. Now, let's go back and look at, our original discussion about objectives. Why a company drug test determines how a company does its drug testing. And that's all a reflection of what's articulated in the policy. The policy, as I like to say, becomes a blueprint to a successful drug-free workplace effort. And that's why supervisor, manager training becomes so important, because on a day-to-day basis, they're the ones out there on the plant, on the construction site, et cetera, who are going to make it or break it as far as your program goes. One of the objectives that always occurs is safety. It could be the safety of your workforce, the people who come into your places of business, or just the general public that's passing by your construction site, et cetera. So if you're in a safety-sensitive industry, that may seem obvious, but even in sort of non-safety-sensitive industries, like retail, working in a retail store, that kind of thing, that becomes an important consideration to include in your policy. And then, of course, if you fall under the DOT regulations, that's part of it as well. These are some of the other ones that we talked about earlier. I'm not going to go into them in great detail, but how you test will be determined by why you test. So let's go back, see if I can go back a slide or two to the list that we had. So this is a question that I get all the time. Just as one example of how we identify our objectives and then make sure that it's reflected in the purpose statement and then an explanation of why we test and when we test. So let's say, for example, that at your company you have an unacceptable accident rate that's resulting in an unacceptable rate of workers' compensation claims being filed, and your insurance rates just went up as a result. So the company comes together and they think, we've got this policy, doesn't really have any teeth to it, so let's make this policy work to our advantage. And so you start talking about what can we do in terms of drug testing and alcohol testing, but drug testing in particular, to address this issue that we have with accidents and workers' compensation claims. What can we do in conjunction perhaps with our insurance provider to get our rates back down again? And so the knee-jerk reaction to that is to go to post-accident testing. But in the very nature of the name, the problem's already occurred, right? Because it's a test that occurs after the accident. It's a post-accident test. It's valuable. It really may come in handy if you're in a state where employers have the right, and this exists in virtually every state, to at least challenge, if not deny, workers' compensation claims, a workers' compensation claim based on the individual failing a drug test. So a post-accident test, very, very valuable, could save you a lot of money. But if the objective is to reduce accidents, then post-accident testing doesn't really address that particular objective. Reasonable suspicion may, okay, that comes into play. Return to duty happens after somebody's been in a drug program and they're coming back to work. Follow-up testing is then keeping them honest, right? Pre-employment, that could play a role as well. But probably the type of testing that has the greatest deterrent impact on drug abuse that may then reduce accidents down the road is random drug testing. And that may be a form of drug testing that you're not currently doing, but one that you should possibly consider doing if one of your objectives is to reduce accidents, to increase the safety environment of your workforce. And then you get into the particulars of random testing. Who is it going to apply to? All workers or just those in safety-sensitive positions? Does our state law allow us to test all workers, or does our state law restrict random testing just to those in safety-sensitive positions? You start getting into all of those different areas. And, of course, I'm not talking about a DOT policy where random testing is required. I'm talking about where it's by company choice. And so you would have the authority to make that decision for yourself. Many states, and we're going to look at a couple of examples towards the end of the presentation. Many states don't touch on this issue in any detail. And there's really only a handful, a very, very small handful of states that either don't allow random testing or restrict it so severely that it makes it almost impossible to do random testing. It's a shrinking number that you can count on less than the 5 fingers on one hand. Years ago, though, it was a hot issue, and it was one that the business community had to focus on because there were state laws being passed that were severely restricting employers' rights to do random testing. But the discussion's not necessarily about random testing. It's about what type of testing should you do to increase the opportunity to actually accomplish your objectives, to get the return on investment from drug testing that you're looking for. And I've done an entire presentation on random testing. To take a full hour just on that topic. But if, for example, safety is your big concern and you're in a safety-sensitive industry, you want to try to stop drug users from causing accidents before they happen, of course. And random testing has proven to be a very powerful deterrent to drug use. In fact, if you go back to that Navy study that I was talking about earlier, actually it was a study that came out previous to the one I referred to earlier, but they identified random testing as the #1 deterrent to drug use. And I think this was years and years ago when the Navy implemented the first massive random drug testing program by an employer. And they did a survey of Navy enlisted personnel, and 27% indicated that they would go back to using drugs if the Navy discontinued its drug testing program, which was based almost, not entirely, but primarily in random testing. So that's significant. A lot of people stop using drugs when a company implements random testing, and according to that Navy survey, a good percentage of them admit they'd go back to using drugs. In other words, if the deterrent was removed, they'd go back to using drugs. Well, the same is true in the private sector. When employees know that they could be picked at any time for a drug test, they're less likely to come to work or be at work under the influence of drugs. And if your concern is accidents and safety, random testing may be something that you want to implement into your program. You don't even have to do a lot of it. There's what we call a random frequency rate. That's what percentage of your workforce will actually be called on for a drug test. And it's a difficult way to explain it, but it's not actually, for example, if you have 100 employees and you're doing a 50% frequency rate, doesn't mean that 50 different individuals will be tested. It means that you're going to do 50 random drug tests a year. Part of the deterrent impact of random testing is that after each time in which names are randomly selected, everybody's name goes back into the pool. So even if I got picked, I understand that I could get picked again. So the deterrent impact stays in place. So as we talk about safety, one of the ways to deal with safety, to address safety, is going to be reflected in how you do drug testing. And so in this one example, random testing may be the thing that you want to do. In other words, here's your objective. What type of testing will help you improve your chances of achieving that objective? And then having that articulated in your policy, communicated obviously to your supervisors and managers, but also to your employees as well. And as you go through all the different lists here, productivity, controlling the cost of doing business like insurance costs and things of that nature, those are all considerations that you should think through as you decide what kind of policy you're going to have and what kind of drug testing in particular you're going to use. And then the consequences of violations of the policy also needs to be communicated to your workers. I always recommend be fair and consistent, of course, comply with state laws, and then look at, within the parameters of the state laws that apply to you, what your options are. Are you in a state that doesn't allow first-time termination unless the employee doesn't cooperate, things of that nature? Should you suspend individuals for a first-time positive, pending their voluntary participation in some type of treatment program? And if you do suspend them, do you do so with pay, without pay? There are all kinds of issues that you want to take into consideration there. And there are some state laws that sort of dictate to you. If you suspend somebody, you have to do it this way. If you don't, you do it that way. How you treat first-time offenders versus repeat offenders, employees versus job applicants, things of that nature. But that would all be part of the consequences section of your policy. And that's very, very important to look at. And then now I want to just spend a little bit of time. I only have a few minutes left before we get to the Q&A, but I want to talk a little bit about state law amendments. So you're in a number of different states, and you write your policy based on Florida law, for example, which outside of the voluntary workers' comp premium discount law that we have here in Florida, there are very, very few restrictions on drug testing. But I'm also in a state like Minnesota or Vermont or Maine, and I don't know why you would want to go from Florida to Maine, no offense, but this is the beautiful time of the year to be here in Florida. The weather's great. But those states, Minnesota, Maine, Vermont, have very, very restrictive drug testing policies. They don't prohibit drug testing, but you really have to know what the law says in those states, or else you can find yourself out of compliance with the state law requirements. So you've based your law on a very drug testing friendly state like Florida, or excuse me, your policy, you based it on a very drug testing friendly state like Florida, but you also need to comply with the more restrictive requirements that are in place in Minnesota, for example. And so your policy needs to reflect that. You don't want to write a policy for your Florida employee that is under the same restrictions that applies in Minnesota. So instead of having a restrictive, unnecessarily restrictive policy here in Florida, we would write an amendment. You would want to have an amendment to your policy for those requirements that apply only to employees who live and work in Minnesota. That's when it's needed. When you're in multiple states and you have one state where the law differs from how you've written your base policy. You don't necessarily have to have multiple policies. There are certain circumstances where you do have to have an individual policy for different states. For example, if you're in Ohio, Ohio also has a voluntary law, somewhat like Florida, that offers multiple levels of discounts for workers' compensation premiums if you participate in the quote-unquote voluntary program. In Ohio, they actually require a separate standalone policy for that program. And so when you qualify, when you apply to be in that program, you have to show that you have a policy that complies with the requirements of that particular state law. The nice thing about Ohio, unlike a lot of other states with these voluntary workers' comp discount laws, is Ohio actually posts on its website a model policy to use. So that's the best way to go when you're in Ohio. But that's an example of where maybe we've written a policy or you've written a policy that covers your Florida operations. You've got an amendment for Minnesota. You've got an amendment for Maine. You've got an amendment for Vermont. But you're also in Ohio. You want to get into that workers' comp premium discount program. so you're going to need to use that Ohio policy. That's an example among a very few examples of where you might have a standalone policy. Another example of that is outside of state law, it's federal law. So if you're under the mandate of the U.S. Department of Transportation drug and alcohol testing regulations, you would need a separate policy that reflects all of the requirements of the DOT regulations. You probably wouldn't want all of your other non-DOT workers around the country to necessarily be part of that same policy. So, for example, if you've got truck drivers, you fall under the Federal Motor Carrier Safety Administration regulations, and they require that you do random drug testing at a 50% frequency rate. And so let's say you got 200 drivers and 100, you're going to have to do 100 random tests under that. But for your non-DOT workers, maybe you don't want to do random testing, or maybe you don't want to do random testing at a 50% frequency rate, or some of the other requirements that for example, under the DOT regulations under certain drug testing situations, you would have to do an observed collection of the voiding of a urine sample. Maybe you don't want to apply that same requirement in non-DOT settings. So you would have your DOT standalone policy, of course, in case you got audited, you make sure you want to have that. But then you might have a separate policy for all of your other non-DOT operations. That would be one example. I'm not going to go through all of this, but this comes out of a state that actually articulates in detail what your policy has to include. It doesn't provide a model policy for you, but it's sort of indicative of a handful of states where they really go into detail about what your policy has to include in it. And so if you're an employer in one of these states, you would actually go through line by line to make sure that your policy includes all of these different points, all the way through, paragraph G gets into rehabilitation services and length of time that an employer can be subject to follow-up testing and things of that nature. We won't go through all of that. I did put on here a sample from our website, statedrugtestinglaws.com, of a state. This is Iowa. It's an old chart, February 2012. But it tells you a little bit about what's required, and then you go point by point to make sure that you understand that, say, for example, in Iowa, I said Ohio, I meant Iowa, that random testing is permitted except for workers not subject to tests pursuant to a collective bargaining agreement. Well, that's very confusing, right? So you're going to have to really get into the statute to read the details and understand what they're referring to there, as well as other components that may be in the Iowa law or may be reflected in another state law. But you also want to look at the practices and procedures that are required. So remember, we have a policy section that, in your policy, you've got a section that's dedicated to how drug testing will occur. So you might have, you might be doing on-site testing, point-of-collection testing. Is it permitted? Yes. You want collection procedures to comply with state laws? Are they required? Yes. And what are they? All the way down to whether or not, if you use a laboratory, it has to be a certified laboratory, and if so, by what certifying agency, in this case, SAMHSA, split specimen requirements, use of a medical review officer, who pays for a drug test. All of those things are covered by many state laws and therefore would have to be covered in a policy that's going to comply with those state laws. And there are a number of different areas as well. So kind of gone through this very quickly, and there's a lot of information that we could cover. Just to give you a little bit of an example, we're going to go into a Q&A session now, but the bottom line when it comes to a policy is, one, you have to have a policy, and two, you need to make sure the policy reflects your drug testing objectives, and three, you're looking at that policy on at least an annual basis to review whether or not the policy is working for you, whether or not the objectives are being met in a way that's satisfactory to you, to make sure that your policy is doing what you need it to do. So I'm sure there's some questions. Let me turn it back over to Meredith, and we can go. We've got time for some Q&A.
Okay, great. Thanks, Bill. Great information there. We just have a few questions here. I've got several questions that were along the same lines. A couple of people asking for the slides or if this was recorded. I am recording this presentation, and when I get it uploaded onto YouTube, I will go ahead and send the YouTube link to anybody that's interested. If you are interested in receiving a recorded version of this webinar, you can email the address there on the screen, the info@edgeinformation.com, and let me know, and I'll send it over to you. And we also have the slides available as well. Okay, getting to the questions here. The first one is, if a new hire tests positive and you must withdraw the offer, can they reapply at a later date and retest? If so, what is the recommended time frame for a waiting period?
Well, that's a great question. There are just a few states that sort of mandate what how that situation should be covered. But generally speaking, you can, the most common length of time that I will see in a policy that I'll have it asked of me to put into a policy is 1 year. It can be less than that, of course. Beyond that, I will every now and then, especially with employers who are in safety-sensitive industries where, this is a safety-sensitive occupation, they will want in their policy that the individual can never apply for work again with the company. And unless the state law says something to the contrary, you can put that in the policy, but I don't know how well it's going to hold up. For example, the Americans with Disabilities Act does not consider a current drug user to be a protected class. They do consider current alcoholics to be a protected class. So there are restrictions on what an employer can and cannot do related to a current alcoholic. But for drug abusers, they're not covered under the ADA, so they don't have those same protections that an alcoholic or an alcohol abuser would have. But if somebody comes back 6 months later, they've gone through some type of drug treatment program, etc., and they want to reapply for a job, there's a possibility that person could make an issue of it if your policy says they can never apply again with the company. How far that could go, it's hard to say. But generally speaking, the vast majority of the time, the length of period of time that I see in a policy is 1 year.
Okay, thank you. Next question is, what is the best way to implement a random program, and how do we choose those random people?
Well, I could probably refer, the details of that question back to Meredith or somebody who works with her. But the first thing I would do if I was considering random testing is I would look at the state law first and foremost to see what it says about random drug testing. Does it restrict who can be subject to random testing? Does it articulate how random selections will take place? Does it have any information or requirements in it on the frequency rate that an employer has to use? Things of that nature. And then work with your drug testing provider. Like, for example, Edge Information Management can actually provide a random selection program for you, and then that truly random selection process is out of the employer's hands and into an objective, unbiased third party's hands to do that for you.
Okay, thanks. All right, next question. Going back to the medical marijuana, what is the best way to handle that in a policy?
Excellent question, and one that is really a hot topic now. Medical marijuana, as well as in Washington and Colorado, recreational use marijuana. And I should point out, Oregon also was considering a legalized marijuana law back in November. Voters there voted against it, but in Washington and Colorado it was passed. There are actually 18 states and the District of Columbia that have medical marijuana laws today. Not all of those medical marijuana laws by state have any provision in them for the workplace. Some do, like in Connecticut, which passed a law last year, which essentially, according to the Connecticut law, this is interesting, so let me take a minute to tell you. In the Connecticut law, it says that employers do not have an obligation to accommodate the use of medical marijuana in the workplace. So you think on the one hand, that's great. That's what an employer wants. But then later in that workplace provision, it also says that employers cannot fire somebody for medical marijuana use. They can't not hire somebody because they're a medical marijuana user, or discipline them or threaten them in any way. Now, of course, we wouldn't want an employer to threaten somebody, but it really sort of said, nothing in this law says you have to accommodate medical marijuana use in the workplace, but you can't do anything about it if you learn that somebody is a medical marijuana user. And that perhaps might mean learning about it through a positive drug test. Now, my response to that is always there are other issues at play usually when somebody goes in for a drug test. For example, unless it's a random test, if it's a reasonable suspicion or a post-accident test, there are other aberrant behaviors that perhaps are violation of company policies, maybe a different policy, but a violation of company policies for which an employer might be able to take adverse employment action. Okay? Enough said on that. But the big question I get asked today as far as marijuana goes, in a lot of these states, like those with medical marijuana laws and the two new recreational marijuana use laws, is can I still test for marijuana? And the answer is yes, absolutely. You can test for marijuana, and you can still hold employees responsible for being under the influence of marijuana in the workplace. Remember, you're going to define what under the influence means in your policy. And one of the ways that you define it is a positive drug test result. There is no law that prohibits you from doing that and then holding an employee responsible or accountable for violating that part of your policy. When it comes to medical marijuana, there was a landmark court case in Michigan last year in which Walmart, now this was over a period of more than just last year, but an employee of Walmart who was a registered medical marijuana user in the state of Michigan tested positive for marijuana. Well, the Walmart policy doesn't take into account why you use marijuana or where you got your marijuana. It just prohibits employees from testing positive for marijuana. So Walmart fired this individual. The individual challenged it. It went through a couple of years of legal back and forth and whatnot, and then finally last year, a judge in Michigan ruled in favor of Walmart, stating essentially that, well, the medical marijuana law in Michigan removes criminal penalties from individuals who are using marijuana for medical purposes. It's silent on the issue of employment, and it says nothing about removing any type of workplace or private sector enforcement efforts to ensure that employees are not under the influence of marijuana regardless of why they were using it or where they got it. And so if you go back and you look at the 18 different state marijuana laws, including Michigan, and then the 19th, the District of Columbia, you don't find a lot in there, almost anything in there on workplace drug testing and marijuana use. And so I think what we're going to see going forward is a lot of, amendment language being introduced in various states that have medical marijuana laws to try to change that so what happened in Michigan doesn't happen again. But it underscores the fact that employers still have the right to test for marijuana. They still have the right to hold employees accountable for being under the influence of marijuana while at work and meting out some type of disciplinary action. In the case of Walmart, they chose to fire the individual. Okay? The whole argument, the compassion argument of medical marijuana aside, which is a legitimate thing to bring into the conversation, but all of that aside, employers still have the right to do those types of things that they've done in the past to ensure that their employees, while on the job, are not under the influence of, among other things, marijuana.
Okay, thanks, Bill. We just have a couple more questions here. How should a company handle drugs like salvia, spice, or bath salts that are starting to become popular?
That's a great part of the whole discussion right now. There are, I don't have it in front of me, but I think there are 42 states that have passed laws banning K2 spice, which is synthetic cannabinoids, and maybe 41 or so states that have passed laws banning bath salts, these substituted cathinones. And so employers have the right to insist that employees are not under the influence of these substances while at work, and they need to articulate that in their policies. And that's something that would require most companies, the vast majority of employers, to go back and amend their policies to include language on that. But it's important. It seems obvious on the surface that you can, but you should nonetheless articulate it in your policy that individuals may not be at work under the influence of these synthetic drugs like K2 spice and bath salts and whatnot. Put that in the policy, but understand that regular, traditional urine testing, for example, or any other matrix like oral fluid or hair, traditional testing will not detect synthetic marijuana. There's a separate type of test for K2 and spice, as an example, and you would need to, communicate with and arrange with your drug testing provider if you wanted to test for those substances. But even if you're not going to actually test for those substances, you can nonetheless include it in your policy that individuals may not be under the influence of those substances while at work. Drug testing is a way to really put some teeth into that policy, but there would be a certain deterrent effect by having it in the policy and communicating that to your workers and your job applicants, even if you weren't testing for those substances. And a lot of drug users don't realize that a regular drug test won't detect those substances, so they may be deterred nonetheless. But there are specific tests out there for synthetic cannabinoids, for example, and you would have to arrange to have that test done.
Okay, the last question here is asking you to go further into the having multiple locations and which law they must abide by.
That's an excellent question. It's Drug Testing Policy 101, so I'm glad you asked that question. All state laws apply. That's kind of the basic answer to the question. But if you're in multiple states and you have business operations in multiple states, then the drug testing law of each of those states applies to your company. Now, let's say I'm housed right here in Florida, and all of my employees are right here in Florida, and I have a policy for my company that's based on Florida law. And I'm traveling to Colorado, or I'm traveling to California or Massachusetts, another couple of states that have these sort of restrictive legal environments when it comes to drug testing. In Colorado, it's the city of Boulder primarily. Well, while I'm traveling for the company, the law of the state where I'm traveling to doesn't apply to me because I'm still domiciled and I still work here out of Florida. But if I had two employees who worked out of an office in Massachusetts or Connecticut, the law of that state would apply to those workers. So the simple answer to the question is each law that you have, the laws that apply to you are the states in which you have business operations, not where you're traveling to necessarily, but where you actually have business operations and employees who work there. One of the confusing issues an issue that is confusing, I think, to many people that I always get asked that's related to that is, what if I have an office in New York and I have workers who live in Connecticut and drive into New York? Well, that's a legitimate question because the drug testing law of New York and the drug testing law of Connecticut are very different. But it's where your business operations are. So when they commute from Connecticut to the office in New York, your policy is based on New York law.
Okay, thanks, Bill. So that's it for the questions. I'll just reiterate that if anyone has any questions that they think of later throughout the day, feel free to give me or Bill a call or an email. Both our contact information is available there. And I just want to thank everyone again for joining us today. Hopefully you found this webinar educational and enjoyable. And again, if you have any additional questions throughout the day, please feel free to contact us. And thank you, Bill, for taking your time to put on this presentation. It was great.
My pleasure. Thank you.